to digress. Now, these are all judgments that you're relying on of Article 356. Article 356, where the role of the governor stands on a very high footing. The responsibility, accountability is more. Now, we are dealing with the threshold under 17A. It is not destabilizing or the government. It's article invocation of Article 356.
Grateful for the.
Should this be the parameters of consideration?
I'm grateful for the query. Three answers. In fact, it's very grateful. Again, was very relevant. Answer number one. This is our 356 case.
No, the other cases that.
This one is a case where the governor directed a floor test.
Yes.
Which would, according to me, considering issues like confidence in the House and majority, are possibly the least reviewable, although I argued successfully in this case, I would not say it today. But compared to what your Lordship is dealing with, your Lordship is considering review. This is less reviewable in principle. But the review here is much more direct and robust.
No, true. These are matters where review or the action should be on a...
No, it's the other way around, with respect. Your Lordship's satisfaction on the filter, it's only a statutory provision your Lordship is to do.
That's all. This is what we are dealing with.
Only a statutory provision. Therefore, your Lordship's review
17A.
Suppose, you replace the governor with the Secretary to Government of India. Why does your Lordship review become less because it's the governor?
No, that's not.
He's in no zone.
No.
He's in no non-reviewability zone.
Interpretation of a statute, yes. The examination is the same.
Materials.
But in a case where judgments which concern Article 356, can we paraphrase those things to a 17A case?
So, I have cited three kinds of cases.
Yes, sir.
General power of governor is the first category, Samsher Singh.
Yes.
It is not, it is a general 163 and all that case, not a case of either 356 or anything else. Second category, one case is a 356 case.
Yes.
Third category is about floor test.
Floor test. Yes.
Now, I'm asking myself the question. In normal exercise of statutory power by any authority, let us replace the governor with Secretary to Government of India.
Yes.
Your Lordship applies beyond the Tata Cellular test now. Tata Cellular is the old case now.
That is true.
So many new cases have come. Your Lordship looks at Wednesbury unreasonableness. What are the tests? Let us look at the test for just 30 seconds. Wednesbury unreasonableness. No material on which you could have come. Taking into account relevant considerations. Failing to take into account relevant considerations. Taking into account irrelevant considerations. It's a case of no reasons, no ratios, etc. Which way it falls is not the point. Your Lordship does full review. On the contrary, when political thicket comes, your Lordships does do review. The advance of Bommai was to say that your Lordship is not shut out. It is not to say that review is more than normal. It is the other way around. Your Lordship were prior to Bommai shut off. Your Lordships entered much more into review because of Bommai and these other cases coming later. This case which I am on 17A has always been reviewable. I mean, not 17A, but similar. Much more reviewability. So, and yet, this is the other part. 17A, let us say, is a public servant who is the Deputy Secretary. They are all considerations the court must keep in mind. There is 17A, let us say, Additional Secretary. There is 17A, Secretary to Government of India. There is 17A, a Minister.
To everyone.
And there is there is a 17A, Chief Minister.
Yes.
So, with a full, robust reviewability of a statutory power, your Lordship has the heightened consequence that the protective umbrella, if not reviewed properly, can lead to an elected government falling, which does not happen. So, as you go up my ladder being Deputy Secretary to Chief Minister, the reviewability becomes more careful, scrutinized and pointed, because there is the additional disadvantage of governments being toppled by this. Otherwise, why do your Lordship create 17A for the higher political part? There are two parts of 17A. One is the bureaucratic part. One is the political part. The political part has the additional liability that you destabilize. Consider, that's why I said the first para of my submission is that, first para. Your Lordship has something running. Your Lordship has always wrongs in an elected government. Any passerby walks in and says, I want to criminally prosecute after 23 years. The total span is 23 years, active span is 10 years. Then why have a filter, If you have a filter, then why have a filter which is limited review by your Lordships? If you have a filter, why have a filter where the governor does not exercise objective criteria? But the governor in a matter like a floor test must have objective criteria, which is more political. I would say with greatest respect, Paulus, that this is a more political thicket than the one I am arguing. Therefore, the conclusion should be the opposite, that your lordship's scrutiny should be more careful and heightened, because your lordship is not in a classic unreviewable political thicket area. Your lordship is, of course, on the straddles, on the margins of both. But Paulus, here it is really, this part is intra-house, where your lordship has 212. Your lordship doesn't go in the house. Of course, the governor is outside the house, but otherwise, Paulus, intra-house is protected by 212. So, Paulus, your lordship is more cautious here. Lordship is more vigorous in my case, is my humble submission. Now, 17. Then comes MP Paulus. The question was governor, etc. Now come to 8 at page 17. This is a very important one.
Yes.
The said decision held. Now, Paulus, first point about MP. Totally misunderstood. Automatic. Take the name cabinet, take the name CM, take the name governor. MP says, automatically I can go. Actually, the first two paras of MP say the opposite, which I have quoted. Opposite. Undoubtedly, in a matter of grant of sanction to prosecute, the governor is normally required to act on aid and advice. We have made the exception into the rule. Let us look at the rule first. This is the rule. My learned friend started with the exception, and not in his discretion. However, an exception may arise, mark the word may, while considering grant of sanction to prosecute as chief minister, where as a matter of propriety, the governor may have to act in his own discretion. Similar would be the situation if the council disables or disentitles itself. Suppose, my lords, there is an allegation that 60% or 50% of the council conspired under 120B. The last sentence will apply. Or my lord finds a group of 3-4 people. Certainly the council has to first consider the grant of sanction. We also presume that a high authority like the council will normally act in a bona fide manner, fairly, honestly. All this is forgotten. It is straight push button, automatic. That's the error. First part. I'm coming to the second part. However, on those rare occasions where on facts the bias becomes apparent. Now mark this sentence, kindly. This is the
apparent bias.
Apparent bias. And or the decision is not the subconscious or institutional bias. You must be presumptively biased because you are a cabinet. But apparent bias is some demonstration. Some demonstration must be there. And based, and the decision is shown to be irrational and based on non-consideration of relevant factors, the governor would be right on the facts. First test did not apply in MP. Second test, not applied by the governor in my case. That's the only test applied by MP. Now, let's just see this. Para 9, 18, page 18, para 9.1. Where on the facts there is a case of apparent bias, this did not arise in the facts of that case. Where the decision of the council was shown to be irrational and based on non-consideration of relevant factors. They are the only two tests. Only. And one did arise. And that one is applied in my case. The decision says, now mark these words for us. Now, this is the context in which I should read M. The decision of the Supreme Court does not lay down any presumptive rule that in all cases where the chief minister or member of the council faces prosecution, there is necessarily an apparent bias. This is a question my lord rightly put to me. However, as third line, as stated above, unless a situation arises as a result whereof the council of ministers disables or disentitles itself, the governor in such matters may not have any role to play. No automatic. Taking a cue from Antule, it is possible to contend that a council may not take a fair and impartial decisions when their chief minister or other members face prosecution. But the doctrine of apparent bias, however, may not be applicable in a case where a collective decision is required to be taken under a statute in relation to former ministers. In a meeting of his council, each member has his own say. There may be different views or opinions, but in a democracy, the opinion of the majority would prevail. Mr. Sorabji has not placed any material to show as to how the council collectively or the members of the council individually were in any manner whatsoever biased. Mr. Sorabji is arguing the opposite point of view. This case, my case, Wallace, this is very important. I'm sorry to repeat.
No, we will take it that the Council of Ministers cabinet had suggested something. You admit that governor is empowered to disagree. It is not that he has to follow. He can disagree.
Provided. No,
he can disagree. Caveat, of course. He can disagree. If he can disagree, then why at all we get into all this saying that Council of Ministers and the role of the governor?
I'll tell you.
In the disagreement, whatever you say, he should record reasons for disagreement. That is all.
Little more complicated. Little more.
Yes.
I understand what my Lord is saying. My Lord is saying the governor can decide.
Yes.
Then we just look at the reasons.
No, is it that whatever the cabinet says, the governor says yes? That is not the scheme of the constitution.
Equally. Whatever the cabinet says, the governor can always say no is also not the scheme.
Yes.
Now, therefore, when your Lordship formulates it thus, the governor can decide. I would like to say, well, that's an incomplete sentence. Let me add the suffix. I would put my proposition as the governor can decide, provided the following 2 or 3 conditions are fulfilled. A, it's a cabinet chief minister or cabinet minister case. That is done. That's the fact. Otherwise, it will not arise. 2 crucial conditions. Can decide if A, there is a demonstration and a prima facie finding of apparent bias. B, if there is shown manifest irrationality. And C, either or both of these must be reflected in the order.
Yes.
This is the correct formulation in my view.
All right. We'll take it. Now, in MP's case,
yes.
Why did the apex court say it suffered from irrationality?
Yeah, that's coming.
It said because a report was not taken into consideration by the cabinet when they recommended that this should be the action. So the apex court said that report should have been taken note of and then permitted a prosecution.
And the governor also said so.
Governor had said so.
Governor gave reasons.
Yes.
And dealt with it.
Yes. No,
I'll check
up that. See, paragraph 26 onwards of.
That's exactly quoted coming up.
Yes.
So therefore, let us just stop with the principle. The governor can decide subject to at least 3 conditions. Let us get that clear.
All right.
Then you will also apply it to the facts of my case. Condition number 1, apparent bias, which must be recorded by my lords as if I am the governor, I will record. Prima facie apparent bias because something, the example is best. Two best examples come to my mind. Let's be very specific. The chief minister saunters into the room and then walks outside. I didn't take part in this. The chief minister's relative is sitting in the council as some other member. Or collectively there are 2 or 3 ministers involved in this so-called allegation. Second, having recorded that is one head. He doesn't record that, doesn't arise. Then he says, even though there is no apparent bias, I find manifest irrationality, which is very simple. Manifest irrationality is a more heightened version of your Tata Cellular.
Yes.
It is what? The best example is what my lord just now said. There are 3 vital documents which Mr. Ravi Kumar as the Council of Ministers did not look at. But they were present and available to him. Then he gave a decision without looking at them. Then they came to me, I am the governor. I looked at them and said, look, A, these show culpability. B, more than that, Mr. Ravi Kumar never saw them. Therefore, though Mr. Ravi Kumar's counsel is not biased, it is manifestly irrational. That is a very simple way of putting it to the best of my ability.
Yes.
That is also a salutary and correct test because your lordship then gets an anchor to decide. Your lordship doesn't lay down law for me or him alone. Your lordship lays down law generally. This becomes the anchor to decide it very easily. And it subjects them to the discipline of your lordship's court is the most important. Either governor is beyond review.
Oh, that's
if he is not beyond review, which nobody is arguing, then it can't be a cosmetic review, a superficial review, a futile review.
By this court.
By this court.
Yes.
Your lordship must have some teeth to catch on, which is this teeth between his report and my judgment. This example is a good example. Now, this is very interesting. Come to the next para. Mr. Sorabji has not placed any material to show as to how the Council of Ministers, collectively or the members of the Council individually, were in any manner whatsoever biased. This is very important for my case. Because I kindly note one more thing. Your lordship is dealing with a very weird case. Your lordship is dealing with the converse of this of MP. MP, they rejected Mr. Sorabji on bias. And in my case, the only ground is bias. I don't want to overstate. Please don't. Yes. The only ground is only. In MP, they held irrationality. In my case, the governor doesn't address irrationality. Forget finding. That's as simple as that one. So they are actually mirror images of each other. There is also no authority for the proposition that a bias can be presumed in such a situation. My Lord Malus, I'm very grateful for the question, therefore. It's very important. The real doctrine of likelihood of bias would also not be applicable. So they said we'd applied. If we applied, we'd apply likelihood, not subconscious bias. And likelihood doesn't arise in this case, MP is what the court is saying. The decision was taken collectively by a responsible body in terms of its constitutional functions to repeat only in a case of apparent bias. Now, just pause here. Let us not go further in MP. How was MP cited by the other side and how was MP cited by the governor in his order? Was not MP cited in the order clearly as a case of presumptive bias?
It was.
I'm very grateful.
I mean, it's a matter of record.
It's a matter of record. I mean, it's not that we are saying something, or lordships can't change the language, I can't change the language. This is exactly contrary to the case cited by the governor. This MP is saying no. And we are all reading it and saying yes. Thus, now I'm summarizing MP. I'll come to the other paras of MP very interestingly on the irrationality.
Irrationality. So the bias is over now.
Oh, yes. Thus, so well, because bias was actually what is argued by them also.
Yes, that is.
And by the governor's order, it is argued there. Therefore, it is important to get rid of this part first.
It refers to real likelihood of bias. So even that is not applicable.
Also a very important query in the morning session. 1, bias can be. 2, bias can't be presumptive. 3, bias has to be, if it arises in a case, likelihood of bias. Your Lordship knows very well what likelihood of bias is. Your Lordship deals with every case, well as Nemo Judex itself has well as all those sub rules, etc. And 4, it must be shown, but I am asking myself one question at the top of page 19.
Yes.
The last 2 lines of 18 and 19 top, not identically my case. Should I be citing MP or should they be citing MP? I don't want to oversimplify or over-exaggerate. Just read those 2 lines. This is my case. Thus, the decision was taken collectively by a responsible body in terms of its constitutional functions. One sentence only. This is what happened here. But you said that a collective decision by a constitutional body is per se presumptively biased by misreading MP. Now, 11.1. The contention, take it out, the judgment. No, the judgment MP. The contention that the decision of the Council of Ministers was tainted was expressly rejected at para 24. The reliance placed on para 17 in the written submission of the opposite side.
Yes.
They adopt the error, Manas. They adopt the error. The decision is not an authority on the point of apparent bias, as the facts in that case did not concern prior approval or sanction of a chief minister. The Honorable Court thus made only a stray observation that in such cases, it may be possible to contend that there is an apparent bias. The next line says, but we are not called upon to decide that. Now, Manas. The decision of the court turned down 11.3, not on bias, but because there was an express finding that the decision of the council was ex facie irrational. This is 11.3. And because it failed to consider Lokayukt report, as my lord just pointed out, recommending registration of an offence, which was relevant material. Please note paras 24 to 31. Now, I'll just read this part, then I'll read those paras. Let me finish reading this part. I'm applying it immediately to my case.
Yes.
Applying this to my case, there must be overwhelming material based on which a prima facie case is clearly made out. And despite this, prior approval is refused. That's as simple as that. The cabinet says, don't give sanction. Material says to the contrary. The governor says, this is the material. You are wrong. Then your lordship will not grudge him the power. But he can't just walk in and apply an automatic presumptive test.
There the cabinet had fumbled in MP.
By not looking at this Lokayukt
report.
The observations at 32 of the MP sanction order of the governor dated 16/8 have nothing to do with bias and are rendered in the context of irrationality and arbitrariness, as is plain from the preceding paras 24 to 31. That's the judgment actually, which we have forgotten. We are going on bias. The judgment is not on bias at all. And you are not giving an order on irrationality. Then how are you relying on the judgment? In any event, in the facts of the present case, the order of prior approval does not contain any reason why the decision taken by the council was irrational. Nor is there any basis for such a finding. The governor does not record that there is a certain relevant material. Your Lordship put a simple question. Which material does the governor say that the council, Malus, of which I was head not for that meeting, has missed out? Which Lokayukt report? Which report? It doesn't say so. Even assuming without considering there is apparent bias is a ground enabling, there exists no apparent bias in the present case where the Chief Minister not only recused himself, not attended the meeting, nor participated in any deliberation. Given that there is no declaration of law in MP, forget the last para. Now, I'll just read that MP for a minute. Which volume is this? It is?
And
Volume 2, Malas, Case Law, Volume 2. Earlier one. Relevant at page 339. The page is the bottom of the page. Not marking. Judgments problem. Give me the marked lines. Give me blankings.
page 3.
Is the same volume?
2, yeah, same.
Huh? This is volume 2.
Yes.
So why are you saying 339?
No, there is no 339.
This 339. It's changing here. Changing. Well, volume 4, 231. And
Volume 4.
yes, it's apparently the pages are not matching. Just giving it.
What case I case later?
No, which case is this?
Page 2, 213.
Which case are you showing?
339.
MP at 230 of, is it marked volume 4? Volume 4. Mark it volume 4. Yeah. Mark it. This is the latest one. Mark it.
No, 230 is Nabam Rabia.
Earlier that.
Earlier to that.
Latest today's volume. Last volume. I
Today's
gave.
volume.
230 is Navam Rabia?
Yes.
Mr.
This
Solif
is
Farabji has not
210,
placed-
210. In today's volume, MP Special Police is 210.
I'm on the relevant portion, 230.
2?
230 is the relevant portion.
Yes. 230.
So this para your lordship has seen, Malas,
Yes.
already. Mr.
Yes.
Solif Farabji not placed on record how, may I read this? Not placed on record how Council of Ministers collectively or the members of the council individually were in any manner whatsoever biased. There is also no authority for the proposition bias can be presumed in such a situation. The real doctrine of likelihood also not be applicable. Right, Malas? This your lordship is read with me.
Yes.
Now, on the same analogy, in the absence of any material brought on record, may not be possible to hold that the action on the part of the council was actuated by malice. So far as plea of malice is concerned, the same must be attributed personally against the person concerned and not collectively. But the whole council is malice.
Yes.
My whole council is malice attached in a uniform manner. Even in such a case, the person against whom malice on fact is alleged must be impleaded. However, here arises another question. There are two competing orders. Now, this is where the thing changes. One of the council, another by the governor, one refusing to grant sanction, another granting. The Council of Ministers refused to grant sanction on the premise that there existed no material to show that R4 in each appeal had committed an offence of conspiracy, where the governor in his order was clear of the view that materials did disclose. An FIR was lodged in relation to the commission of the offence. Now, Malas, this is enough, I would say, for your lordship to send any matter back saying council is wrong.
Matter back?
Any matter your lordships can say the council is wrong if para 28 exists.
Yes.
Anybody would say it, Malas. I'll not read it. How is it that the council ignored a Lokayukt report of such detail, Malas? It's as simple as that. And this case is being applied for the other point, for the bias point. This para 28 in my case applies in my favor. I hope.
Yes.
28 is omission of looking at Lokayukt. The omissions of looking at reports are by the governor in my case, today's case. But your lordship said there applies to the governor here. And we'll just see the report of the Lokayukt itself gives the material at the bottom of that page. Your lordship is ignoring everything at the Council of Ministers, then why will your lordship not intervene with us? At the bottom of that page 230, the Lokayukt is quoted. The point is not that they are right or wrong. The point is they should have noticed it, dealt with it. They did not. And then 29 Malas, they say how high the Lokayukt office is.
No, 29, sir.
Yes.
Last 5 lines.
Yes.
30
30?
and 32.
Your lordship is on 30?
30.
Yeah. May I read the last 5 lines? It is now
last 5 lines of 29.
Yes.
And
Now, while settle that refusal to take consideration relevant fact or acting on the basis of irrelevant experience not germane to the purpose would vitiate an administrative order. In this case, on the material disclosed by reward Lokayukt, it could not have been concluded that no case was made out. This is they are talking about the council.
Yes.
Now, it is well settled exercise of administrative power will stand vitiated. There is manifest error of record or the exercise of power is arbitrary. Similarly, if the power has been exercised in the non-consideration or non-application of mind to relevant factors, the exercise of the power will be considered manifestly erroneous.
Now 32s.
We have, well, just 31 for a minute also.
Yes, sir.
31. We have no hesitation to hold that decision was ex facie irrational. This is that manifestly irrational. This is about the council. Exactly these words apply to the governor with great respect. Whereas the decision of the governor was not. That's the competing thing your lordship is looking at. Is your lordship told after so many days of hearing which part of the governor's report tells you, which your lordship is reviewing, that this part of the council of ministers has omitted this? It's as simple. Well, we can all argue all these things. Has your lordship been answered that simple question by the governor? My lord is not sitting as a reviewing authority of the council first. First comes the governor.
No, of the governor. Yes, correct.
In a situation of
32,
this
32 is what the apex court.
the facts of these cases, the governor cannot act in, there would be complete breakdown of the rule of law, be open for governments to refuse. This is in the light of that he must act at his discretion because he finds that the lokayukta is missing. Does it say, Malaj, that governor can act at his discretion after Shamsher Singh downwards without giving a single reason as to what is wrong with the report in which he is acting at his discretion?
So everything boils down to the fact that he is entitled to disagree. The disagreement, yes, should be recorded. What is irrational in the note in the cabinet decision should be recorded. And the decision should
crux.
be taken.
That's the crux.
That is all.
That's the crux.
Yes.
But Malaj, only with one caveat, even the starting point should be a little cautious. You should not say that first thing is I can jump in. You must look at it cautiously in a harmonious manner and then say, look, I am not for a minute suggesting that your lordship has a case like this, where he has not looked at Lokayukt. I am the governor, I point out Lokayukt, and your lordship says, no, the council is right not to look at the Lokayukt and the governor is wrong. I can never say that. But it's very, well, nothing is not rocket science.
Yes,
It's very
so-
commonsensical. And this also gives the court proper basis for review. It gives the proper test for review also. But Balas, it leads to the interesting conclusion that MP in last sentence and MP Balas is either completely in my favor or completely not applicable on bias
Yes.
or completely misapplied by the governor.
That we'll see.
All these three things.
Yes,
Balas.
the apex court holds it is not a judgment for real likelihood of bias as well. So,
Yeah, well,
yes.
they didn't go into it. They said that, but Balas, that
But the
sentence
submission itself is negative.
negative. And Balas, 1 second, I'm sorry to repeat. One of the reasons negative is the last line of 18.
Yes.
That is the reason it's negative. They are saying, well, actually they don't say it in one sentence, they say it in two different sentences. It is negative, as the lordship says, because they are rejecting the doctrine of presumptive bias.
Yes.
That is the point.
Yes.
That is the take home as far as I am concerned.
Yes. Yes.
That doctrine of presumptive bias is rejected at bottom of 18 and top of 19.
Yes.
They are
Yes.
saying it amounts to this, that you are saying per se there is a cabinet, there is a governor and there is a chief minister, therefore out you go. Now let us page 21. Now this is the heart of the matter. As I said from the beginning, this is by itself sufficient ground to quash it. Just see the actual exercise of power. Now I am assuming for the minute they're in exceptional. I am never agreeing, Malus, that in the walk-in, walk-out manner in which they are saying. Exceptional cases, I am agreeing. Your lordship is the judge of exceptional. Not a judge of Malus, just people coming and telling you that they say you can walk in because there is a 154 paragraph, Justice Krishna Iyer, and the rest of the judgment doesn't repeat it, or because the MP means this. No. But yes, exceptional, where my lord is satisfied, then yes, you can walk in. Even assuming that the governor has, in exceptional circumstances, to depart from the aid and advice, the power not to be bound does not ipso facto justify the exercise of the power in every case. This is the presumptive argument, where approval under 17A is granted based on the independently exercised discretion of the governor. The validity of the exercise of this power requires two further conditions, which are both conspicuous by their absence. I'm repeating one, though, but I must repeat here, with a separate head. Two conditions what I told you, Lordship, must indicate why the advice of the council is manifestly irrational, or at least substantively indicate why he is persuaded not to follow such advice, which in the normal and ordinary course he is bound to do. The governor must affirmatively, although not exhaustively, indicate why upon a consideration of materials he has formed a view that inquiry or investigation is warranted. A negative and a positive, or whichever way he wants to put it. Both these tests are not even addressed or applied. Forget your lordship, Allah's finding and then reviewing. Not applied or addressed. In terms of the decision of the MP, para 15, the power of the governor to differ with the aid and advice is predicated on a finding that the aid and advice is manifestly or ex facie irrational. It is therefore incumbent on the governor to record reasons as to why he is constrained to differ from the aid and advice, as also state the factors that weighed with him in arriving. Now, Vittal Das is an interesting case, fellows, on sanction. It's rather well put, fellows. Sanction lifts the bar for prosecution. The grant of sanction is not an idle formality or an acrimonious exercise, but a solemn and sacrosanct act which affords protection to government servants against frivolous prosecutions. Sanction is a weapon to ensure discouragement of frivolous and vexatious prosecutions, safeguard for the innocent. Next sentence is important. The validity would therefore depend upon the material placed before the sanctioning authority and the fact that all the relevant facts, materials, and evidence have been considered by the sanctioning authority. Consideration implies application of mind. I'm relying on these 5 lines very much, fellows. The order of sanction must ex facie disclose that the sanctioning authority had considered the evidence and other materials placed before it. Then they cite a series of judgments, fellows, and I'll skip, fellows, to save time. Kranti is cited by me in para 17. And if your lordship goes beyond Karti, the next page, 2010-9 SCC, where the summary I have reproduced with 2 or 3 underlinings at page 24 of my note. In India, the judicial trend has always been to record reasons, even in administrative decisions, if such decisions affect anyone prejudicially. And D, recording of reasons also operates as a valid restraint on any possible arbitrary exercise of judicial or quasi-judicial or even administrative power. And then, Malas, it's a very long list and it's a useful list. So I've read, Malas, A and D, and then read L also for London, Malas, L. Reasons in support of decisions must be cogent, clear, and succinct. A pretense of reasons or rubber stamp reasons. This is another very interesting passage. Had your lordship got the formality of reasons, your lordship is not obliged to accept it. Your lordship is not looking at rubber stamp procedures. Is not to be equated with a valid decision-making process, but your lordship is fortunately at a one stage anterior. There are no reasons to this issue. The reason is why I am not bound. That's all, nothing else. Chairman Mullahs of Kakkar's case at page 26. Now, this passage I picked up because this ratiocination is very well defined in this para, rather well put. Come to page 26, 4th line, 5th line. Reasons are live links between the mind of the decision taker to the controversy in question and the decision or conclusion arrived at. Reasons substitute subjectivity by objectivity. The emphasis on recording reasons is that if the decision reveals the inscrutable face of the Sphinx, it can, by its silence, render it virtually impossible for the courts to perform their appellate function or exercise the power of judicial review in adjudging the validity of the decision. How much more will it apply than in this case? Well, I throw a bunch of 1,000 pages at your lordship and say, look, my order is 5 pages. I don't address it, but you'll find something there. And then your lordship looks there, finds a comparative chart. Directly this para, I would say, well, I may be wrong, applies to my case. Right to reason is an indispensable part of a sound judicial system. Another rationale is that the affected party can know why the decision has gone against him. All these are reasons, fellows, why it has gone against him. One of the salutary requirements of natural justice is spelling out the reasons for the order made. In other words, speaking out. Speaking judge, a speaking out. The inscrutable face is ordinarily incongruous with a judicial or quasi-judicial performance. Although the governor is no doubt a high constitutional functionary, this is my submission. The very nature of the power being exercised in this case, and the fact that it's an exceptional power, as he is ordinarily to be bound by the advice of the council, would suggest that the exercise must be accompanied by reasons. The governor's impugned order instead presents the inscrutable face of the Sphinx, and it is impossible to discern from what factors it has arrived at and weighed with disregarding. Now, as your lordship decided Sri Rupa for 17A, yes. I don't think Sri Rupa means what has been said to your lordship it means. It is very clear what it means to me, and I have tried to explain that at 27. 17A casts an obligation of application of mind on the part of, just pause here, Malos. Forget 17, 19, 80, whatever, 287, etc. The concept is basically your lordship should be satisfied of substantive application of mind. Otherwise, your lordship is not allowing shadow boxing by saying this is little less, this is little more. Substantively. The section makes it clear that no officer shall conduct any inquiry without previous approval. Therefore, the approving authority will have to look into the materials, apply it minds in each of the 3 contingencies, inquiry or investigation. This should go someday. This E and I difference is very, very difficult.
difference.
And it's, well, sometimes it really becomes a technical one. They should use a different word in the CRPC and this thing. You're arguing about inquiry and inquiry all the time. Though inquiry and inquiry are often used interchangeably, there exists a difference between the two. Etymologically, the source of both inquiry and inquiry could be the same, as en is derived from French and in is from Latin. Inquiry has a formal and official ring to it. Inquiry is informal and can be unofficial. Inquiry would even mean a question to question. Inquiry is a formal investigation. Investigation is search. Now I'm reading the underlined portion. Therefore, the Act casts an obligation of application of mind upon the authority to consider whether approval is sought for an inquiry, or an investigation. It becomes imperative for the authority to apply its mind to what is brought before it, as application of mind is the bedrock of any order that an authority possesses. Failing it should be contrary to the principle of natural justice, as non-application of mind is itself violation of the principle of natural justice. And there is no answer to this to say, my order be damned. The application of mind is in the interstices of the mass of 1,000 pages which I have in my office. That's the crux of it. That's the only thing they are falling back on. And that is, a travesty of how I will appeal, how I will react, how I will deal with the order, how your lordship will review it. It's only, a desperate attempt to justify it because they have not done it. So now they've come up with this thing about papers in the office. Application of mind by an authority is demonstrable. Mark the word demonstrable. Only in the order that the authority makes. Now, I'm asking myself, what are we talking about, Wallace? This is my Lord's judgment which was cited against me. What is my Lord? I was not aware, Wallace. I'm not there in the matter. I have not checked the facts of Shirupa. I can guarantee that Shirupa could not have been a case of a 5-page order with a 1,000-page file. It must have been a better case.
There was nothing in the file, nothing in the order.
Now, Wallace, application
because
of
file
mind
was summoned.
No, but your Lordship puts it very clearly.
Yes.
According to me, the Lordship has to have black and white, which is what your Lordship has done here. See the first line. Cited against me. That's the irony of it. Is demonstrable only in the order that the authority makes. My humble and respectful service, that's the correct view, Wallace. We are not playing Wallace games here. For the order to demonstrate application of mind, it must contain the reasons. So your Lordship goes further. First is what is on the order, not what is in my almirah. Second is the reasons in that. As recording of reason and order is the only way that can construe such application of mind. Then your Lordship gives this very felicity. That's why I quoted the Supreme Court first. Reasons are the links between the mind of decision taker to the controversy and the decision arrived at. Ratiocination, I call it.
Yes.
Reason and application are impregnable. That's a new word, Wallace. Ratiocination, impregnable. No, because this is important, Wallace. This is how administrative law is built up.
It is inseparable.
Public law builds up like this only, Wallace.
It is inseparable.
For an order to sustain the scrutiny of law, be it administrative or quasi, reasons in every circumstance need not be elaborate, no problem. Nevertheless, should bear application of mind. The case at hand and the order impugned will have to be tested on the anvil of the matter statute, the intent and the rule of application of mind. If on a coalesce of all the facts that are narrated herein above, and the order that is impugned on the anvil of this object and reasons, it would fall foul of the same as the order. Now, let's kindly bear with me here. As the order, except saying there is nothing indicative of the fact that it bears application of mind. Granting approval for setting the criminal law in motion cannot be a frolicsome act as is done by the state in the case at hand, as it does not even bear any semblance of application of mind. As this frolicsome should also be adopted by some other courts.